Alex here with part three of the, mini series that I'm doing on the Brittany Spears conservatorship. And by mini, I should say micro. The real stuff is out there on other channels, the drama, the details, specifically the facts and circumstances. There's a Netflix documentary now, which is what kind of prompted part three. But again, as with every other video on this channel, I have a very narrow perspective that I want to bring to you guys just to give you something new that's consistent with what I've always done, which is to focus on the statutes, the rules, the case law, and the procedure and the law itself, as well as with regards to the micro series, is just the sort of public perception and how far off course it is. And I think that's why it's been so jarring for the public, is just this disconnect from what they think the court system is and reality. Um, so a lot of times what I notice when I look at some of these videos is how much time they put into just trying to explain to people, ordinary people, what guardianship, which is what we call it here, conservatorship, which is what they call it in California, explaining to people what that is. And it just reminds me of when I had no clue about the court system. I just knew there was a court system, there were courtrooms, there were lawyers, and there were judges. So this is one of the things that I have to kind of ground myself and realize that how can you expect people to fix a legal system when they don't even know what a basic mechanism is? Like, conservatorship, guardianship is such a basic thing. I mean, it's not as popular or as common as child custody and divorce, but it's not that far away from it. And yeah, so just kind of, if any of you out there are ever wondering why you're just alone in your struggles with the court systems, most of my viewers are child custody, visitation, etc., high conflict child custody viewers. Just keep in mind that Brittany Spears is like known by everyone, and yet all the people who know who she is don't have a clue, or probably 99.9% of them don't have a clue what conservatorship even is. And so you can see how difficult it might be to get other people to understand you when, if they haven't gone through it, their level of understanding is so abysmally low. One of the things that they highlighted was there was, I guess, some discussion by it was an attorney, I guess, who is part of the sort of the subset of the subset, is what I've called it before. Let me explain that again. I believe family law is a subset of law. It's, there's a giant legal system out there. Family law is just a small part of it. And it's very insular. And I've already explained this before, that the insularity of it and the way that they exploit privacy and confidentiality is one of the hugest problems with regards to the family court system. You take guardianship and conservatorship, and you have a subset within that subset, an even tinier niche with even less attorneys involved, with even more secrecy involved. And that, watch part two of the Britney Spears discussions that I have up, because I talk more about that issue in part two, or maybe it's part one. You should really watch both parts one and two if you're on part three now. Anyway, this attorney, said that he thought it was odd with regards to Britney Spears, because she had a job and all of the other clients, they couldn't even manage to get their own, food and shelter. So this is one of the things that I really wanted to point out in this video, because so many times I'll hear from attorneys, less often judges, as they don't really get into policy as much. What I hear is, we don't need that many laws. We know how to do the right thing. That's obvious. That doesn't have to be in a statute. Well, here's a really, really famous person who's got a job, and she's making so much money that she's got, like, I don't know how many people on her payroll, and she's under guardianship / conservatorship. So maybe there does need to be a statute, because there wasn't one there, and the right thing didn't happen. I just struggle really hard to imagine how a person can be deemed incompetent and yet make that many millions of dollars while they're incompetent. I just it's just one of those things that I can't bend on. And I can't even say but, or I just can't. And I think it would have helped a lot for there to have been a statute that said if somebody is able to hold a job, that establishes a presumption that the court cannot impose guard. I mean, like, I just can't get past that. It's so difficult for me to try and get into. You know what it reminds me of? It reminds me of when my family court judge ordered midnight exchanges for my son. It just is not based on logic or reason. It's something else. Um, and I could imagine people saying, okay, well that's just one example. No, there's another thing that's come out in this case. It's pretty obvious, and that's the ability to hire your own attorney. And this even came up in Nevada. And in Nevada, it came up in Nevada in a guardianship case, and they didn't even need a statute. The Supreme Court of Nevada lambasted the respondent on that appeal for thinking that a person couldn't choose their own attorney. And the arguments that were used were, I mean, I don't know if they were verbatim, but I did hear something in there in the documentary about lacks the capacity to retain or advise counsel, and that does kind of jog my memory with the appeal that went up in Nevada. I don't even know. I mean, I wish I could remember the number, the case number, or maybe even it published. I guess if people really want me to find it, post something down in the comments and I'll track it down. But I remember that coming up in Nevada, in the Supreme Court of Nevada, just destroyed them. And I don't recall there being any statute that said so. So they must have used some constitutional principle or some case law. Well, in the California legislature, they're contemplating, and maybe it's already been passed, a statute, because I guess the judges there can't figure this out, that, yeah, you do have the right to choose your own attorney, which is, again, one of those things that I just cannot understand how a judge could have possibly reached the opposite conclusion. I know that you can come up with these plausible, with, I know that anyone can come up with an argument for anything, but there is some kind of threshold, right, where you just have to say, come on. And so, anyway, I really want to highlight this before I move on, the whole point of her not being able to choose her attorney, because I talked about this a lot in part 2, and I mentioned that the ability of her to choose her own attorney would be the beginning of the end of everything for the conservator and all of the people who were ripping her off. And I ended up being right. I'll talk more about that a little bit later. But apparently, according to the documentary, this wasn't the only time that she tried to hire her own attorney. There was a prior time. And I guess she went in to a lawyer's office and she signed this declaration stating she wanted this other lawyer to represent her, and they filed it in court. And the documentary alluded to the document coming up in court, and what they did was they just said that she didn't sign it. And I suppose there was enough doubt that she didn't sign it that the judge just decided, I'm not gonna follow this document because she just didn't sign it. I'm just gonna declare she didn't sign it. I'm gonna make a finding she didn't sign it. I'm gonna conclude she didn't sign it. This one of those things where it would be really nice to have a video, but because it's so secretive, there's no video, so all you can do is fill in the blanks, and that's what I'm doing now. Is I'm just going to fill in the blanks and just assume that that's how the judge squashed it. I really want to highlight this because, like in part 2, the ability of an attorney to control a case is profound. And that was, in my opinion, going to be what could get this case to go in another direction. It wasn't all the publicity. I do think that the attorney, like any attorney, can weaponize the media and weaponize the public, and when it's in their client's best interest, that's what they'll do. But I do think that the public in and of itself and the media attention also in and of itself would not have been enough to end this case. It was going to take an attorney, and it was going to take an attorney who was going to wreak havoc on all of her adversaries ruthlessly and mercilessly. And that's what it was going to take, and that's what it ended up taking. I'm going to talk more about this a little bit later. I'm going to move on to preference of a private guardian over a family guardian. And again, guys, in California, they call this conservatorship. So that would be conservator. An attorney talked about this. I think it was the same attorney that I'd mentioned before. And he mentioned that he preferred private guardians over family because the families often were very complex and there were issues with them. My personal opinion is that his concern is valid. It is valid. And it's one of the things that I think society doesn't like to talk about. And I think if society did talk about it more, that we would have less issues in child custody cases too. This notion that all families are wonderful and that's really what you have to put first is not true. Not all families are wonderful. There are plenty of toxic families out there. I wouldn't even say it's 1%. I wouldn't even say it's 2, 3, 4, 5, 6%. It's probably a substantial number. It's probably not 50%. But if I was going to spitball a number, throw a number out there, I'd say at least 12%, maybe as many as 30%. Those are extreme boundaries, but somewhere in that field, I would say there are toxic families. And it's enough of a thing that more attention needs to go into this because it affects how people grow up. It affects pretty much everything in a person's personality and approach to life. Pretty much everything is affected by that. And so I think that some child custody judges do understand this, especially those involved in high conflict child custody cases. I don't think many other judges do that are not in the system. And I think that the approach that a lot of these family court judges is wrong. But going into guardianship, you're going to have the same sort of thoughts from me, which is that they probably are aware of it and their approach is probably wrong. And that maybe it's wrong because they're afraid. Maybe they're afraid that they can't go out there and say, no, your family, can't have, control over your, maybe it just sounds bad. In any event, I don't really have a really strong rule, sort of, whether it should be one or the other always. It really is one of those things that probably should lean in favor of family being in control, but leaning in favor doesn't mean that's what you should do every time with rare exceptions. I think that it should be seriously considered whether or not there are, responsible, wise family members that can be selected. And if not, then maybe they should choose a private guardian or the public guardian. This is something that I really like that the attorney brought up because it's something that I do believe is a valid concern and that you're just going to have situations that come up where a family member just exploits the protected person. Just like a private guardian could have done it, family member can do it too. And so it's one of those things that requires a family court judge to do their job and get to the bottom of things, not be lazy, not rush through cases and just rubber stamp everything, but pay attention. So anyway, that's my opinion on private versus family as the guardian / conservator. Is I do lean in favor of family, but that any concerns that have been raised in that area should be addressed. They should not just be sort of brushed aside. Pay attention, get to the bottom of it, and if it's not looking like that family member is going to do a good job, or if they're showing examples, if they're doing things that are harmful, then take action. Don't just stick with it just because they're family. Look more into what the family dynamic is. Next, I wanted to talk about what I call the shenanigan of the 5-day time limit. I don't know what the time limit is in Nevada. I sure hope it's more than 5 days. But apparently in California, if you serve somebody with this sort of document, they're supposed to have 5 days to get an attorney and file an opposition or an objection. Apparently that didn't happen. Apparently she had a boyfriend that they claimed was so dangerous that they needed emergency relief and they needed to impose the guardianship immediately. So 5 days, which is already not enough, turned into, who knows, 0 days notice? Maybe she just got an ex parte, hey, you're already under guardianship. Welcome to us controlling your stuff. Maybe that's what happened. I think that should be investigated to the point of judicial discipline and disbarment. I really do. They should find out what attorneys were involved in bypassing the 5-day rule, and if there was any dishonesty there. I don't know how you cannot disbar that person. It's so difficult because you're just imagine somebody just coming up to you and giving you a court order and saying, we control your bank account and your life now. it's not a normal type of thing. And the thing that really makes this worse is that once she was under the guardianship slash conservatorship, they immediately moved to step two, which is you don't get your own attorney. We're going to just give you one. And it's this series of events. It's the combination of all of these things together that makes the dishonesty, if there was any, which I do feel there probably was, so egregious. And same thing what I mentioned for the judge. I mean, if the judge did something that she shouldn't have done with regards to this 5-day time limit not being complied with, judicial discipline. I mean, to me, you're like, they call it a civil death sentence, I guess. Same thing that they do for the termination of parental rights. It's like this person's no longer a person. They're almost a slave. When they're working, at least. If they're not working, maybe not. But I don't know. I mean, if you guys watch the documentary, let me know what you think about the whole 5-day time limit and how they got around it. Because to me, that was instrumental. It was almost like they were playing chess with her life. And every move was so carefully calculated to not just impose the guardianship or conservatorship, but to also deprive her ability to communicate to the court. Because once you can't communicate to the court, they can do almost anything they want. I've talked about this before in other videos. I don't know if I've talked about it in the Brittany Spears videos, but the way that I've seen attorneys lie to the court is by not lying. It's by leaving things out. So say that there are 5 or 6 different things that are relevant for the court to consider. What the attorney will do is they'll only bring up the things that make their case look good. And attorneys would probably say, well, yeah, that's the adversarial system. The other attorney is supposed to be the attorney who brings up the things that would make the other side's case look good. So obviously you're not going to want to bring up, the things that are damaging to your case. You're going to bring up the things that strengthen your case, and they're going to bring up the things that strengthen their case. Well, what if they don't have an attorney? What if the court chose one for them? What if that attorney isn't really on their side? Then now you have this problem where you have the attorney who wants to impose conservatorship bringing up the things that are relevant to that and leaving everything else out. And then you have the other attorney who's been appointed to her. Maybe he wants the conservatorship. Maybe he thinks that that's going to be the better way for him to make money, because then he can collect fees out of the estate. So if he wants it too, he's not going to bring up the things that are going to cause the court to question it. He's going to bring up the things that are going to lean in favor of it. And I've also heard that in California, apparently that the attorney does not have to argue the client's wishes. In Nevada, they do. In Nevada, even if the client's wishes are damaging to the client, even if the attorney feels that, the attorney still has to argue for that, even if he feels it's going to hurt the client. They do have a guardian ad litem in Nevada who's able to sort of do the other. They're able to sort of consider the wishes of the protected person, but they can argue differently based on what they feel is in the best interest of the protected person. So in Nevada, we've separated those two roles out so that there's a GAL who does that, and then the actual protected person gets their own attorney who will, well, at least they're supposed to argue what the protected person wants, no matter what. If they don't feel it's good, too bad, so sad. You need to argue it. In California, apparently, that's not how it works. The attorney can say, well, this is what my client wants, but I don't think this is a good idea. And so I'm going to just leave a bunch of things out because that's not good. Let's do what I think is better. And that's the problem here. And that's one of the biggest issues, I think, with the guardianship / conservatorship is the way the attorneys work is very different. I feel like it really is. You take all of the bad things about family court generally, you put them on steroids, and you have conservatorship / guardianship. I think that's my opinion, is all of the evils and wrongs are just exacerbated in that system, because now there's even less oversight. Now there's even more secrecy. Now there's even less attention. And then there's an even tinier pool of attorneys who are practicing there. And so it's just easier for them to get away with that. Moving on to the next topic. And with that, I'm going to dovetail into what I call the extreme brazenness of it all. If you take a step back, you have to really wonder, aren't rich celebrity people supposed to be powerful enough to deal with, these types of situations? These are the situations that ordinary poor people, regular people, you just get stuck. There's attorneys who are, abusing the system, judges who are just going along with it, and you're just a nobody. There's nothing you can do. Well, hold on a second. She's a somebody. There is supposed to be something she can do. She's supposed to be able to. Well, this sort of disconnect for me highlighted just how brazen the attorneys participating in the conservatorship system in California are. Number one, she could have all the money in the world. They have control of it. She can't use it. She can't even pick her own attorney. So that's one huge thing that they've taken away from her. Because when it comes to other celebrities and rich people, they have a lot of money and they can get whatever attorney they want. They can get 5, 6, 7 attorneys. So that was the biggest thing that they took from her, is you can't get your own attorney. And yeah, you're rich, but it's our money now. It's not yours. And then the other thing, which was the shield against the press, is the privacy laws and the confidentiality of those cases. So these participants in this system, the attorneys and the judges apparently, were able to exploit those flaws to such a degree that they were even able to do it against Brittany Spears, who has gajillions of followers and all this money. And to me, it just screamed at me. It's like, just how brazen, and in my opinion, in any other type of situation, it would be reckless. But I mean, they've got that system under wraps, and they were able to do it to her. And it just really, it shouldn't shock me. I mean, I've done my docket series. I've done this. I've been doing this channel for years. It shouldn't shock me what happened, but it really did. It really did blow even me away. And it makes me wonder if attorneys and judges who are not in that particular system, who have probably seen everything, would have also been shocked and blown away by what happened, by what occurred, and by what has probably been occurring. And I'm pretty close to wrapping things up here at this point. A lot of people, they have this instinct, pinpoint the lawyers, pinpoint the judge, pinpoint the doctor who conducted the evaluation for Brittany, and punish them and move on. I do think that is important on some level, but in my opinion, it's not the most important thing at all. In fact, it's pretty low on my totem pole of importance. I understand that. I mean, I used to be there. I mean, that's what I used to think too, is just, fire the problem people. But then I realized the system itself really does have to change. You can fire these people. They'll just be replaced by other people who are going to do the same thing. Most of the time, I think I've described with the analogy of just a slope, and gravity just causes the water to roll down the slope in the direction that it's been slanted. And that's just how I see most of the issues with the legal system, including family court, including guardianship. And my opinion is no longer that you can just kind of find out who all these evil people are and replace them with all these good people. It's too black and white to go with that approach. It's a system, it's a business, it's a conveyor belt, it's mass production is what I was going to say. It's just designed that way. And so really, to change that, you have to change the actual system itself and redesign it so that it works in another way. The people, the participants, will follow suit for the most part. And I really hope that people pay attention to the importance of statutory language, because that is what's controlling the outcomes of these cases. I've mentioned in parts 2 that the statutes that govern who can impose guardianship and how are different in California. Wouldn't have happened in Nevada, because in Nevada there actually has to be incompetence. And there's quite a few distinctions in the statutes themselves. And as you can see, even basic things that you think that judges would get, behind, like being able to hire your own attorney, they don't. And it really just underlines that you can't just go along with this idea of, it's their system, let them do whatever they want. Even legislators don't want to tell judges what to do. It's like, guys, that's what you're there for. Your job is to control the other branches. So control the other branches. And same thing, my same message is to ordinary people. If you just think you're going to complain and protest and yell and scream and it's going to change, it's not going to change anything. Really, what's going to happen is ordinary people are going to have to figure out how this stuff works and why it matters. And this attitude of just letting them do whatever they want isn't going to work, because if you do, this is the kind of stuff that happens, not just with child custody, but even with guardianship, not just with ordinary people, but even with Brittany Spears. And It's just a problem of not really understanding the importance of the statutes themselves and how they control the outcomes of the cases. Because I think if we can get a lot of people to figure out why that matters, we can get a lot of people to get behind the idea of, okay, we do need to control these people. We can't just let lawyers and judges just do whatever they want. They're causing all kinds of harm all over the place, and it's time for us to actually pay attention and care about how some of these statutes are written. Because I've shown before, even in my own case, if you watch my docket series, how I was able to use the statutes in my case to control what the judges and attorneys were doing in my case, and ultimately I was able to get it all the way to the end, which was a termination of parental rights. Ordinary people are going to have to learn more about how statutes work and why they matter, because that is how you're going to actually change the system itself. Right now, ordinary people understand other people, and ordinary people understand elections and how to fire people in an election. People get that. But that, like I mentioned earlier, doesn't really solve the problem. A new person steps in and they're just going to do what the other person was doing anyway. For the most part, generally, that's what's going to happen. So if you want to actually change the way that all of this stuff works, then you actually have to change the way that the actual statutes were written. It would be nice if the legislature would do that for you, but it's not my opinion that they actually do that. They do kind of sort of respond to public outrage sometimes, and they do, in my opinion, kind of nibble around the edges. You know, they'll kind of pick one or two things and fix those and just leave everything else broken. And I think that's just because that they give more deference to the actual attorneys themselves, because they're the ones actually that are in these cases, to the actual judges themselves. And so, in my opinion, they do just enough to appease the media and appease the public, but they don't really do fundamentally change that system, whatever system we're trying to talk about, whatever system is being confronted by the public. And that's kind of my sort of perspective, is the actual statutes themselves are going to decide how all of this stuff works. And another thing that I want to mention is I've seen situations where statutes will be changed because of media outrage. Maybe 10, 15, 20 years later, they just change them back, or they make them worse even. So, I mean, really, that's what it's going to come down to, is people learning how to judge the competence of the legislature by the statutes that they enact, not just by the things that they say on camera. And if people don't sort of figure that out, you're really going to just continue to see these problems forever and ever and ever. The other thing that is nice is that, I guess in conclusion, and I'm laughing because of how he did it. You know, if you saw part 2, you will have seen my prediction as to what was going to happen in this case once Brittany Spears hired her own attorney. And it looks like everything's starting to go her way. And it looks like it was what I thought, which was that it wasn't going to blow up into some huge legal battle. I mentioned that that was a possibility, but that I was leaning in the direction of this was going to just kind of resolve itself now because she had her own attorney. And that's because of what an attorney can do when they're actually in one of those cases. Because now her attorney has access to all the filings. Her attorney has access to all of the hearing videos if they actually record them there. Her attorney can file a document that can trigger an evidentiary hearing, which can open discovery, which can make the lives of all of Britney Spears' adversaries living nightmares. If he can peel into that stuff and pull account information out, financial information out, and with the resources that she has, he could probably hire PIs and have them all under investigation. My suspicion was most likely that her attorney was going to kill this case without even going to a hearing. And I do think that he is going to a hearing, but I will say this. The conservator apparently filed something with the court saying that he wants to just get off. He wants to end the conservatorship. He doesn't want to be involved, terminate the conservatorship. And so even though there's a hearing coming up, I feel it's a foregone conclusion. I mean, at that point, the guy just caved, which I get the guy, he's their father. He just completely caved. And there was one thing that I saw. There was a public statement apparently by Brittany Spears' attorney right at the end of the documentary that just kind of made me smile, because I mean, I'm sure there is a lot behind the statement that he issued, but I do think that the statement speaks for itself. It's enough that I'm going to read it to you guys verbatim. The statement is this, quote, "Mr. Spears and his counsel are now on notice. The status quo is no longer tolerable, and Britney Spears will not be extorted," unquote. And I think that that was his warning to them. And I'm sure there were off-record discussions with them about what he was going to do. that's all it took, guys, is one attorney who is not part of the club, who is willing to just stomp them all out. And just like that, the conservatorship, I believe, is going to end, not with a bang, but with a whimper. And I mean, like I said, guys, the conservator filed a document with the court saying he wants to terminate it. He wants out. I mean, that speaks for itself. I think it's a foregone conclusion now that it'll terminate. And if it doesn't, I would be very surprised. And I'm just going to say what I said in part 2, which is that lawyer can do a lot. He can do a lot more than the public can do. He can do a lot more than the press can do. He can get a lot of information out that ordinary people can't get out and totally wreck everything. So I do think that this is going to end very quickly. And I hope that this video was interesting to you guys. And if you have any questions, feel free to post them down in the comments below. And I will see you guys next time.
I'm so angry, it's insane, and I'm depressed. I cry every day, and the reason I'm telling you this is because I don't think how the state of California can have all this written in the court documents from the time I showed up and do absolutely nothing. Ma'am, my dad and anyone involved in this conservatorship should be in jail. The last time I spoke to you made me feel like I was dead, like I didn't matter. And I'm telling you this again so maybe you can understand the depth and the degree and the damage that they did to me back then. It's embarrassing and demoralizing what I've been through, and that makes no sense whatsoever for the state of California to sit back and literally watch me make a living for so many people and be told I'm not good enough.